The question is, can you avoid a ban if losing your driving licence is going to have a negative effect on your mental health? Well, there is no single answer to this question, and every case is different. So I'll focus on three common scenarios. Firstly, cases where there is a mandatory disqualification from driving. Secondly, cases where there is a discretionary disqualification from driving. And then lastly, we'll come on to totting up cases where the driver gets 12 or more penalty points. So the first set of cases where there is a mandatory disqualification from driving, the court must disqualify for a minimum period. So think drink driving, drug driving, dangerous driving, cases involving a death or serious injury. In those cases, the court have no choice. If somebody is convicted and there are no special reasons, then there must be a disqualification. So that's in the case of drink driving, drug driving, the minimum is 12 months. And even if the court are convinced that the ban will have a negative effect on the driver's mental health, they cannot go below the minimum disqualification from driving. Now, quite often in these cases, the guideline ban is longer than the minimum. And in those situations, then the defendant's mental health could have a difference, and it could cause the magistrates to come low within the guideline or sentence outside the guideline. But they can never go below the minimum, and so in those cases, negative effect on mental health cannot avoid a driving disqualification. Now, there's another big set of offences where there is a discretionary disqualification from driving. So, for example, careless driving, you can get 3 to 9 points or a ban. Speeding, 3 to 6 points or a ban. Lots of other cases are very similar. In those cases, negative effect on the defendant's mental health could be mitigation. Okay, so if the defendant puts forward mitigation that a ban will affect their mental health, then that is one of the factors that the magistrates or the judge will weigh in the balance when they decide whether there is going to be a disqualification or whether there's going to be penalty points. So in those cases, mental health could have an effect in certain circumstances, particularly on borderline cases. The last set of cases is penalty points cases. So when a driver gets to 12 or more penalty points within a 3-year rolling period, then they must be disqualified, usually for 6 months, although longer if there have been previous bans. In those circumstances, the 6-month ban is mandatory, but if the driver can establish that there will be exceptional hardship, then they could avoid the mandatory disqualification. So a negative effect on mental health could fall into that category. In these cases are a bit different because the other set of cases I was talking about just involve putting forward mitigation. In an exceptional hardship case, there has to be proof. So if the driver could prove that a disqualification, say for 6 months, is going to have a negative effect on their mental health, then that could be something that the magistrates might take to be exceptional hardship, and they could have avoided disqualification. So a common scenario might be that somebody works in a job which requires a driving licence. They're going to lose their job if they lose their licence. That's not normally exceptional hardship. But if somebody's mental health is fragile and part of the rehabilitation for previous mental health episodes is that they stay in work, then that might be something that could be taken into account at court if the appropriate proof was put forward. So the global answer to the question is, can mental health help you avoid a driving disqualification? The answer on that is a big maybe. It depends on the case.